First, the historical context. We all know that the Indian Evidence Act 1872 was one of the earliest codifications of the colonial era. The purpose of Indian Evidence Act was to streamline the judicial proceedings across diverse colonial population with varying customs and practices. The idea was to bring uniformity. The idea was to ease the justice dispensation system, if not justice itself. The idea was to somehow aid the colonial administrative efficiency. This did not necessarily mean that it kind of upholded the participatory justice or human dignity. The Indian Evidence Act was actually designed at a time when, technologies that we have today like CCTV, cloud computing, metadata logs, digital signatures, tower logs, etc. did not even exist. So the concepts like data privacy, cyber forensic trails, cross-border evidences were absolutely unimaginable. And also there was a gross lack of social sensitivity. Perhaps a great example would be child witnesses. Concepts like victim trauma, concepts like gender justice were not legislatively prioritized. So it is hardly surprising that a law drafted when the telegrams were perhaps the fastest form of communication could not see the evidentiary challenges posed by encrypted messages. So the whole idea of bringing this Act, which is BSA of 2023, was a part of the trilogy, and there's a lot of examples I'm going to give you about trilogy, three Dev, so to say. So the three acts were actually changed together. They came with the justice criminal reforms. The whole idea was to align it with technological and, more importantly, forensic advances. This recognized digital evidences as primary evidentiary tool, mandates protocols for authentication, source integrity, acknowledged the role of certain evidences which we now would say AI generated, but they were more like digital generated, algorithm trails, blockchain backed ledgers, etc. etc.